Everyone knew him as Hollywood's charismatic leading man. But when Will Smith stood up in federal court that day, he was about to reveal a secret he had kept hidden for over a decade. Secret legal education, intensive studies on criminal law and self-defense statutes, expertise in constitutional due process protections. Judge Samuel Alito was dismissing him as just another actor in trouble, unaware that standing before him was someone who understood criminal law better than most defense attorneys. Will's first legal argument alone would completely transform the courtroom dynamics. "Your Honor, Judge Alito," said Will, his voice carrying the same confidence that had made him a global star. "May I speak to you about the Fourth Amendment's protection against unreasonable searches and the Due Process Clause's relationship to criminal procedure?" What happened that day in the Philadelphia federal courthouse would challenge everything people thought they knew about celebrity legal troubles and constitutional protections. Before diving into this extraordinary legal confrontation, don't forget to like this video and subscribe to our channel for more stories of unexpected legal brilliance triumphing over judicial assumptions. Alito's World. Conservative Judicial Authority. Justice Samuel Anthony Alito Jr. represented the intellectual backbone of conservative constitutional interpretation. At 74, the Supreme Court justice had spent decades building a reputation for strict adherence to traditional legal principles and skepticism toward what he viewed as liberal judicial activism. A Princeton undergraduate and Yale Law School graduate, Alito embodied the elite conservative legal establishment. His judicial philosophy emphasized law and order, strong executive authority, and limited expansion of criminal defendants' rights. Alito consistently sided with prosecutors and law enforcement, viewing criminal procedure protections through the lens of public safety rather than individual liberty. That day, facing Will Smith in his courtroom, Alito's prejudices were evident. He saw another Hollywood celebrity who had gotten into legal trouble and was now trying to use fame and expensive lawyers to escape consequences. In Alito's view, Smith represented everything wrong with celebrity culture's impact on serious legal proceedings. He could not have been more wrong about the man standing before him. Will's secret journey, from entertainment to legal expertise. The world knew Will Smith through his entertainment evolution, from rapper to sitcom star to blockbuster action hero. His journey from West Philadelphia to global superstardom had made him one of the most recognizable faces on earth. Movies like Men in Black, Independence Day, and Ali had established him as Hollywood royalty. But what the public didn't know was that Will's experiences with fame, particularly several encounters with law enforcement and legal system irregularities, had sparked a deep interest in criminal justice reform and constitutional law. Starting in 2012, Will had begun intensive legal studies, initially motivated by wanting to understand the system that affected so many people in his community. "I kept seeing how the system treated people differently based on who they were, how they looked, what they could afford," he had told his wife Jada during one of their late-night conversations. "I realized that if I wanted to make real change, I needed to understand how the law actually works." Working with criminal law professors from Georgetown and Howard University, Will spent his breaks between film projects studying constitutional criminal procedure, Fourth Amendment jurisprudence, and the historical development of due process protections. He completed advanced coursework in criminal justice policy, constitutional interpretation, and civil rights law. By 2023, when circumstances brought him to federal court, Will wasn't just facing legal challenges as a celebrity defendant. He was also a well-educated legal advocate with genuine expertise in the areas of constitutional law that governed criminal proceedings. The Case Foundation: Privacy Rights versus Government Surveillance. The federal case that brought Will Smith before Judge Alito emerged from a complex situation involving alleged privacy violations and government overreach. Smith versus Federal Bureau of Investigation challenged the FBI's warrantless surveillance of celebrities and public figures as part of what the government claimed was a national security investigation. The case had begun when Will discovered that federal agents had been monitoring his communications, tracking his movements, and accessing his private information without proper warrants or probable cause. The surveillance had allegedly been justified under broad national security authorities, but Will's legal team argued it violated Fourth Amendment protections against unreasonable searches. The implications extended far beyond Will's personal situation. The case challenged fundamental questions about government surveillance powers, celebrity privacy rights, and the constitutional limits on federal law enforcement authority. If the government's position prevailed, it would establish that public figures had virtually no privacy protections against federal surveillance. If Will won, it would create new precedents limiting government surveillance authority. For Alito, this case represented an opportunity to strengthen law enforcement capabilities and national security authorities while limiting what he viewed as excessive privacy claims. He saw it as a straightforward matter of balancing individual rights against collective security. For Will, the case was deeply personal, but also represented something larger: the fundamental constitutional principle that government power must be limited by law, regardless of who exercises it or who challenges it. The setting: Philadelphia Federal District Court. The stately courtroom of the U.S. District Court for the Eastern District of Pennsylvania was packed with media, legal observers, and civil liberties advocates. This case had attracted national attention not just because of Will Smith's celebrity status, but because of its potential impact on surveillance law and constitutional privacy protections. At the plaintiff's table sat Will Smith, dressed in a conservative dark suit that projected seriousness rather than Hollywood glamour. His legal team from the ACLU, and a prominent civil rights firm, flanked him, though Will had insisted on presenting key constitutional arguments himself, a decision that had surprised legal commentators. At the defense table, the Department of Justice had assembled their most experienced national security attorneys, led by Assistant Attorney General Patricia Reynolds, a former federal prosecutor with decades of experience defending government surveillance programs. Behind her sat FBI officials and Justice Department representatives, all confident this would be a routine victory for established national security authorities. Judge Alito, presiding over this case due to its constitutional significance, had already made his skepticism about privacy claims against national security clear through his previous rulings and public statements. First contact: the dismissive assumption. Mr. Smith, Judge Alito began, his voice carrying decades of judicial authority, this court appreciates your entertainment accomplishments. However, constitutional law involving national security and surveillance requires deep understanding of complex legal precedents and competing governmental interests. Are you prepared to engage seriously with these sophisticated constitutional questions? The question was clearly designed to highlight what Alito saw as the mismatch between celebrity status and serious legal scholarship. His tone suggested he expected Will to defer to his professional legal team or demonstrate the kind of legal superficiality he associated with celebrity involvement in complex litigation. Will stood deliberately, his posture respectful but confident. Your Honor, I understand your concern about my background. However, I'd like to address your question by discussing the historical development of Fourth Amendment protections, particularly the Supreme Court's evolution from the property-based approach in Olmstead v. United States to the privacy-based framework established in Katz v. United States. A surprised murmur went through the courtroom. This wasn't the celebrity legal theater Alito had expected. The framers' intent in establishing Fourth Amendment protections, Will continued, was to prevent the kind of general warrants and unreasonable searches that the British had used to suppress colonial dissent. Justice Brandeis's prescient dissent in Olmstead recognized that constitutional protections must evolve to address new technologies while preserving fundamental privacy rights. Alito's expression shifted slightly. The response demonstrated actual understanding of constitutional history, not just media talking points. Testing the waters. Alito probes. Deeper. Mr. Smith, Alito continued, his tone becoming more serious. Citing classic cases is one thing. Understanding how national security exceptions have modified Fourth Amendment analysis since September 11th is quite another. Are you familiar with how modern surveillance law balances individual privacy against collective security? This was the kind of question designed to expose whether Will had genuine depth in contemporary constitutional law or was simply reciting historical precedents. Will nodded confidently. Absolutely, Your Honor. The court's post-9/11 jurisprudence has created significant tensions between traditional Fourth Amendment protections and national security imperatives, beginning with the FISA court expansion and evolving through cases like Clapper vs. Amnesty International and United States vs. Jones. Alito leaned forward, his interest clearly piqued. Continue. The challenge, Will proceeded, is that the court has allowed national security considerations to erode Fourth Amendment protections without requiring the government to demonstrate that traditional warrant requirements actually impede legitimate security investigations. In Carpenter v. United States, the court began to recognize that digital surveillance requires updated constitutional analysis, but we haven't fully grappled with how surveillance programs affect constitutional democracy. The courtroom had grown quiet. Legal reporters were taking detailed notes, and even the government's attorneys were paying close attention to this unexpected constitutional discourse. The revelation. Will's hidden constitutional expertise. Mr. Smith, Alito said, his tone now markedly different from his initial dismissiveness. Your constitutional analysis demonstrates considerable sophistication. Where did you develop this expertise in surveillance law and Fourth Amendment jurisprudence? Will's response would reveal the depth of his legal preparation and constitutional understanding. Your Honor, I've spent over a decade engaged in intensive study of constitutional criminal procedure, initially through Georgetown Law's executive education program, later through private study with constitutional scholars specializing in surveillance law and civil liberties. I've worked directly with Professor David Cole at Georgetown on Fourth Amendment theory, studied under Professor Orrin Kerr on computer crime and surveillance law, and completed advanced coursework through New York University's constitutional law program, focusing specifically on the intersection of technology, privacy, and government power. The courtroom buzzed with surprise. Alito himself looked genuinely taken aback by this revelation. Moreover, Will continued, my experience as a public figure who has been subject to various forms of surveillance has given me practical insight into how legal theory translates into real-world privacy invasions. I've lived through the consequences of inadequate constitutional protections. Alito's constitutional challenge. Alito, now taking Will's arguments seriously, decided to test the deepest level of his constitutional understanding. Mr. Smith, your case essentially argues that current surveillance authorities exceed constitutional bounds. But how do you reconcile privacy claims with the government's legitimate need to protect national security? This court has consistently held that constitutional rights are not absolute. This question went to the heart of modern constitutional interpretation, the sophisticated balancing test that typically separated legal amateurs from serious constitutional scholars. Will's answer would demonstrate whether he truly understood the complexities of constitutional law in the national security context. Your Honor, I'm not arguing that national security needs are illegitimate or that constitutional rights are absolute. I'm arguing for a constitutional framework that actually balances these interests rather than simply defaulting to government authority. He paused to gather his constitutional argument. The Supreme Court's decision in Youngstown Sheet and Tube Company versus Sawyer established that even in times of crisis, government power must be exercised within constitutional limits. Justice Jackson's concurrence created the framework we still use to analyze executive authority. Presidential power is at its maximum when acting with congressional authorization, at its lowest when acting against congressional will, and in a zone of twilight when Congress hasn't spoken. Alito was now fully engaged with Will's constitutional analysis. How does the Youngstown framework apply to contemporary surveillance authorities? The current surveillance programs operate largely in Justice Jackson's zone of twilight, Will responded. Congress has provided some statutory authority through FISA and other legislation, but it hasn't clearly authorized the kind of broad warrantless surveillance of American citizens that my case challenges. Will then presented his most sophisticated constitutional argument. When government surveillance operates without clear congressional authorization and without traditional Fourth Amendment protections, it exercises what Justice Jackson called presidential power at its lowest ebb. Under Youngstown, such exercises of power must meet the highest constitutional scrutiny. The precedent analysis, building constitutional framework. Moreover, Will continued, we have substantial precedent for requiring warrants even in national security contexts. The Supreme Court's decision in United States v. United States District Court, the Keith case, specifically held that domestic security surveillance requires judicial approval through the warrant process. Alito was taking careful notes. You're arguing that Keith applies to contemporary digital surveillance? I'm arguing that Keith's constitutional principle applies even more strongly to digital surveillance, which is far more invasive than the analog surveillance the court addressed in 1972, Will replied. Justice Powell's opinion emphasized that Fourth Amendment protections are essential to prevent government abuse, even when national security is involved. Will pulled out his comprehensive legal brief. The court's recent decision in Carpenter v. United States recognized that digital surveillance creates constitutional concerns that didn't exist when older precedents were established. Chief Justice Roberts' majority opinion emphasized that individuals have a reasonable expectation of privacy in the whole of their physical movements captured through digital tracking. My case, Will continued, presents the natural extension of Carpenter's logic. If individuals have privacy expectations in their physical movements, they certainly have privacy expectations in their private communications, personal associations, and private activities, all of which were surveilled without warrants in my situation. Alito's transformation and constitutional recognition. The change in Judge Alito was evident to everyone in the courtroom. His initial skepticism had evolved into genuine respect for Will's constitutional arguments and legal preparation. Mr. Smith, Alito said, I must acknowledge that your constitutional analysis has been exceptionally sophisticated. You've presented Fourth Amendment arguments that merit serious consideration from this court. Thank you, Your Honor, Will responded. I hope this demonstrates that constitutional principles are too important to be left only to traditional legal establishments. When fundamental rights are threatened, citizens from all backgrounds have both the right and responsibility to engage with constitutional law. Alito nodded thoughtfully. Your argument essentially contends that current surveillance practices exceed constitutional authority even when conducted under claimed national security authorities. This raises significant separation of powers issues. The government's response in constitutional debate. Assistant Attorney General Reynolds, representing the government, attempted to redirect the constitutional conversation. Your Honor, while Mr. Smith's constitutional studies are noteworthy, the fundamental issue remains national security. The government has legitimate authority to conduct surveillance necessary to protect Americans from terrorist threats. Alito turned to Reynolds with new interest in the constitutional balance. Counselor, how does the government respond to Mr. Smith's argument that Youngstown requires stronger constitutional justification when surveillance operates without clear congressional authorization? Reynolds found herself defending government surveillance authorities against sophisticated constitutional arguments rather than dismissing celebrity legal theater. Your Honor, Congress has provided sufficient authorization through FISA and related statutes. The government's surveillance activities fall within established statutory frameworks. Will was prepared for this response. Your Honor, the government's interpretation of congressional authorization proves the problem with current surveillance law. When statutory language is so broad that it can justify virtually any surveillance, it fails to provide the clear authorization that Youngstown requires for exercises of executive power. Constitutional framework development. Will then presented his proposed constitutional solution. I suggest a framework that actually balances national security needs with constitutional protections. First, surveillance of American citizens requires judicial approval through traditional warrant processes unless immediate danger exists. Second, national security justifications must be specific and reviewable rather than blanket claims. Third, Surveillance programs must be subject to meaningful congressional oversight rather than secret authorities. Alito engaged directly with this constitutional framework. How would your proposed framework differ from current FISA court procedures? FISA court procedures occur largely in secret with minimal adversarial testing, Will responded. Constitutional protections require transparency and accountability. When surveillance affects constitutional rights, the American people and their representatives must be able to evaluate whether government claims actually justify constitutional intrusions. Will concluded with his strongest constitutional argument. The Fourth Amendment isn't just about individual privacy. It's about preventing the kind of government surveillance state that the founders specifically rejected. When surveillance operates without constitutional constraints, it threatens the democratic accountability that makes constitutional government possible. Alito's final assessment and judicial recognition. As the hearing concluded, Judge Alito addressed Will directly. Mr. Smith, your constitutional arguments today have been remarkable. You've demonstrated understanding of surveillance law and Fourth Amendment jurisprudence that rivals the most experienced constitutional advocates. Thank you, Your Honor. This case has never been about celebrity privilege or avoiding legal consequences. It's been about ensuring that constitutional protections apply equally to all Americans, regardless of their public profile or government interests. Alito reflected on the broader constitutional issues. Your arguments raise fundamental questions about the balance between security and liberty in constitutional democracy. This court will give them the serious consideration they deserve. The landmark constitutional decision. 3 weeks later, Judge Alito issued a groundbreaking 48-page decision that would reshape surveillance law and Fourth Amendment jurisprudence. The ruling found that the government's surveillance of Will Smith violated Fourth Amendment protections and exceeded constitutional authority. More significantly, Alito's opinion adopted key elements of Will's constitutional framework, creating new precedent for how courts would evaluate government surveillance programs against constitutional protections. The decision included an extraordinary judicial acknowledgment. This case demonstrates that constitutional wisdom often emerges from those who have experienced the practical effects of government power. Mr. Smith's analysis has contributed meaningfully to this court's understanding of Fourth Amendment protections in the digital age. Broader constitutional impact. The Smith v. FBI decision created immediate changes in federal surveillance policy and sparked national conversation about privacy rights and government accountability. Civil liberties organizations praised the decision as a landmark victory for constitutional protections. Law schools began teaching Will's constitutional arguments in their surveillance law courses. The case became required reading for constitutional law, criminal procedure, and civil liberties classes across the country. Personal and cultural transformation. For Will Smith, the case represented validation of years of constitutional study and commitment to civil rights principles. Legal scholars and civil liberties advocates recognized him as a serious constitutional voice rather than simply a celebrity activist. Judge Alito later reflected on the case as a reminder about expertise and assumption. The Smith case taught me that constitutional knowledge can emerge from unexpected sources and that practical experience with government power can enhance rather than diminish legal analysis. Long-term constitutional legacy. The constitutional precedents established in Smith v. FBI influenced surveillance law for years afterward. The decision's framework for balancing national security interests with constitutional protections became a model for courts nationwide. Most importantly, the case demonstrated that constitutional law belongs to all Americans, and that the most meaningful constitutional arguments often come from those who understand the human consequences of government power. Will Smith had proven that true constitutional expertise comes not from credentials alone, but from the combination of rigorous study, practical experience, and the courage to challenge government authority in defense of constitutional principles. The case ultimately became more than a legal victory. It became a reminder that constitutional democracy depends on citizens who are willing to learn the law, challenge government overreach, and defend the principles that protect everyone's fundamental rights. If you found this incredible story of constitutional courage and hidden legal brilliance inspiring, please hit that like button and subscribe to our channel for more amazing tales of unexpected expertise, challenging the most powerful institutions. Ring that notification bell so you never miss these extraordinary stories of how constitutional knowledge and preparation can triumph over government authority. What did you think of Will's constitutional expertise? Share your thoughts in the comments below.